Yes, may call to order the meeting of the Michigan Board of State Canvassers. Director Brader is joining us on Zoom. Director Brader, has the meeting been properly noticed in accordance with state law?
Yes, it has, Chair Gurwitz, and I apologize for again being remote. But as you know, we don't have a lot of flexibility in scheduling these meetings, and I had a travel scheduled. And of course, your in-person availability is more important than mine. So sorry I can't be there, but I am here on Zoom, and the meeting was posted as required.
Okay, thank you. Okay, the first order of business is public comment, and James Gallant has asked to speak to us by Zoom. Mr. Gallant, you have 2 minutes.
Hello, can you hear me?
Yes, we can.
Okay. Yes, James Gallant, Marquette County Suicide Prevention Coalition. These are my opinions. And it appears our case in controversy is centered around your oath of office, the fundamental principles of ethical parliamentary procedure in the United States of America, as compared to your consensus-making, decision-making processes that you currently use as current practice. In my research shows the difference between our constitutional democracy and Marxist-style communalism is the informal consideration of proposals for the business item before a motion is offered, and possibly multiply amended before a formal consideration under a motion with support, while juggling at least 3 questions. You can either approve the certification, you deny it, or you can postpone it, and then you can just make up other proposals informally before you make the motion. In this country, there's 1 question at a time. Robert's Rules of Order, page 366. No debate before a motion second. Members' statements must be germane to the immediately questions of others. My prediction is that Michigan State Secretary of State Joyce Benson will face a recall election concerning, in part, her institutionalizing Marxist-style communism into our constitutional democracy, in direct contradiction to her current oath of office at the State Board of Canvassers and at the Michigan Independent Citizens Registration Commission, which I just attended the meeting this week, and they did the exact same thing. And you're going to do all this business, and it's communist, you know, it's communism, and there's nothing really wrong with communism, except under your oath of office, you are required not to do that. You can do that at your nonprofit corporations, in the basement of your churches, or whatever it is the communists do. But do it somewhere else other than your oath of office. You do it on our dime. We're paying for you to implement Marxist-style communism. And I can tell you, millions of people have suffered and died to protect us from communism. And what happens, this bullying.
Okay, your time is up, Mr. Gallant. Thank you for speaking to us again today. The next order of business is consideration of the meeting minutes for the August 1st, 2023 meeting. Do we have a motion?
I move that we accept the minutes of the last
Okay, all in favor? Aye. No opposition. I would note for the record that Member Bradshaw was unable to join us today. So what we are required to do today is to determine by an affirmative vote of 3 of us, and there are 3 of us here today, whether each reason for recall stated in the petitions before us is factual and of sufficient clarity to enable the officer whose recall is sought and the electors to identify the course of conduct that is the basis for the recall. We have 2 people who have asked to speak to us today on the recall petitions that are before us. Mr. Brewer, will you join us at the podium?
Thank you, Madam Chair. Mark Brewer of Goodman Acker on behalf of the 6 remaining petitions before you this morning. The board should reject all 6 of these recall petitions as set forth in the responses that we filed last week. And I would briefly like to recite those reasons and supplement with additional information that has come into our possession since I filed those responses. As you heard me on August 1st, the board cannot review petitions which are defective as to form. I'll not recite the law again as to this, but again, you have before you petitions which are handwritten and have no disclaimers. At a minimum, each of the sponsors should have placed their name on these petitions in the disclaimer. The campaign finance law is quite clear in that regard that an individual person is subject to the disclaimer requirement. However, we have discovered significant evidence since I was last before you in these matters about a concerted statewide effort behind these recall petitions, which requires the formation of a committee and that committee be registered and report to the Bureau. And with your permission, Madam Chair, I'd like to tender some documents to the board.
Certainly.
This is a picture of a piece of printed literature that advocates for the recall of State Representative Noah Arbit. You can see clearly that it advocates for his recall. It gives a phone number. It gives an email address to which a person can contact to pursue the recall. And it even includes a disclaimer, though defective. But at least there's an attempt there to put a disclaimer there. This, is obviously, we believe, evidence that there is an organized effort, certainly behind Mr. Arbit's attempted recall, if not others. This PAC, which is indicated in the disclaimer, has a Tennessee address, a Virginia bank account, but according to its latest campaign finance reports, has neither raised nor spent any money. So even if it actually paid for this piece, it is lying on its campaign finance reports about the state of its finances. We also have additional information about another group that is actively supporting these recounts. And if I may, Madam Chair.
Yes.
This is an email that was sent out by the Lakes Area Tea Party, again in support of the recall of Mr. Arbit, that indicates there was a meeting that was actually held last night to organize the recall effort against him. But again, no disclaimer and no indication in any of these recall petitions that this group or any committee of which it's a part is behind the recall of Mr. Arbit. We also understand that there's a gentleman named Daniel Lawless who has been organizing the efforts against State Representative Breen. And if I may, Madam Chair, I have yet another document, which is a text message from Mr. Lawless, which we obtained a copy of, that talks about his organizing efforts against Representative Breen. So this is in text message, which we excerpted to protect privacy, dated last Wednesday, that announces that this board is going to approve these recall petitions today, and there's going to be an organizing meeting tonight in support of the recall of Representative Breen. And again, no disclaimer on any of these petitions. They indicate that there is a committee or truly discloses that there is an organized effort on a statewide basis behind these recalls. We also understand, Madam Chair and members of the board, that there are other individuals, in addition to Frank Tarnowski, about whom I spoke to you on August 1st, who are behind the recall petition. There's another person named Frank Slavic, who was here on August 1st. I don't believe he's in the audience today. He has run Republican state house campaigns, and he has been traveling from House district to House district throughout the state, making presentations on these recalls, including a recent presentation to the Oakland County Republican Party. So despite what you have been told under oath, frankly, by Mr. Clixby last time, these are not spontaneous grassroots efforts at all. They're being organized and coordinated statewide with the involvement of at least one out-of-state PAC and a number of other individuals inside the state. So again, in support of our argument that there should be disclaimers on all of these petitions, if they're not individual disclaimers reflecting the sponsors, all of these individuals who are clearly coordinating and working together to make these recalls occur should have formed a committee and placed that disclaimer on these petitions. For that reason, again, we reiterate that these petitions are not properly before you. The board has no jurisdiction to approve them until the law regarding disclaimers is obeyed. A final point, again, as with the first set of petitions before you on August 1st, these petitions, again, in defiance of the board's expressed concern last time, are handwritten, which introduces a number of ambiguities. I think on one of these petitions, there's even a correction. The law is very clear that petitions must be printed or typed. They do not permit handwriting. Beyond these procedural objections, the reasons for the recall are not clear. And if I may, Madam Chair, I'm going to address all of them. There are 3 different types of petitions before you, but it's up to the board as to how you want me to proceed. One of the petitions is addressed to 4 different members. I can address that first if you'd like, but it's your agenda.
Sharon McDonald. Both of those concern what they call the red flag law. They're slightly different, and your argument is slightly different, but I think it would be helpful for us to consider those together. The petition against COFIA is the first item on our agenda with regard to these petitions, so if you can start there. Is there anything that, okay.
Glad to do so. So the petition against Representative Cofia says, on April 13, 2023, State Representative Betsy Cofia voted yes on Michigan House Bill 4145, creating an extreme risk protection order, parenthesis, red flag law, close parenthesis. This reason is unclear in several regards. First of all, the bill does not create an extreme risk protection order. Legislatures don't have the authority to do that. Those are for courts to create, and I cite in our response the provision of this bill, which says an extreme risk protection order means an order issued by a court. So it is not only misleading, but it's factually incorrect under both prongs of the recall statute for this reason to state that the bill, quote, creates an extreme risk protection order, close quote. Secondly, it is unclear what red flag law is. This bill nowhere uses that term, and is unclear from the reference, and particularly the parenthetical, what that phrase is or even what it means. The term red flag is a very common metaphor for many different things. It's sometimes used to describe the weather. It's used in many different contexts. And it's unclear here exactly what context that is. Finally, the law is quite clear, and I won't belabor the presentation I made here on August 1st, that under this board's guidance, under the case law, and under the relevant statute, recall petitions have to give a description of the content of the bill. The content of the bill. It's consistently repeated in this board's guidance, in the case law, and particularly in the statute. This reason for recall does not give a description of the content. It apparently purports to provide some kind of title, and even that title is defective because, as I indicated, red flag law is nowhere in the title, and this is not an extreme risk protection order. So for all of those reasons, this petition should be rejected as not only unclear, but also factually incorrect. The most critical thing here, I think all three reasons are valid, but there is no description of the content of the bill, and the public, a signer, and others are left to guess what the content is. All the examples this board gives in its guidance and in the case law give some indication, some statement of the content of the bill, and this reason does not do that. Turning to the McDonnell petition, which, as you indicated, Madam Chair, is worded slightly differently. In this case, they got the title of the act correctly. They describe it as an Extreme Risk Protection Order Act, and that points out the defect, frankly, in the COFIA petition. That's a correct description of the title of the act. But then again, they use the very unclear phrase, red flag law. That phrase is not found in the law. It's not defined in the reason for the petition. And it is capable of many, many different meanings, leaving the signers to guess as to what that is. But also, like the COFIA petition, this petition does not describe the content of the bill. It simply gives its title. And under the case law, the board's guidance, and the statute, content description is required for the reason to be clear and factual. So both of these petitions, which deal with allegedly House Bill 4145, are neither clear nor factual, and the board should not approve them.
Okay. We also, do we have questions for Mr. Brewer? Because we have somebody else who is also asking to speak to these particular agenda items. So would the board like to hear the other presentation before we question Mr. Brewer, or do you have questions for Mr. Brewer now?
I have a question for Mr. Brewer.
Sure.
Mr. Brewer, I always love to read your letters.
I'm sorry, Mr. Housekamp?
I said I always love to read your letters.
Thank you.
The bold parts are especially exciting. Sir, I looked at your argument last night in your letter with regard to the clarity and the factual. And so after reading it, I went out on the net. And I took a look at, I pulled some stuff down from the Michigan House on 4145, which is heavily loaded with the term extreme risk protection order.
Correct.
Okay, and describes it in detail. PBS, when the governor signed that law into law, PBS, the headline on their piece is Michigan governor signs red flag gun law. The governor herself referred to it as a red flag law. The Michigan Education Association has a piece on their website referring to both extreme protection orders and red flag laws. Red flag laws, by the way, several times. It seems like even in the what's on for the House and what's on for the governor, what's on for the news media, the terms red flag law and extreme protection order are exactly what they use to describe that bill. So my question to you is, isn't part of our obligation to look for clarity and factual clarity? Somebody, to me, somebody that would be signing that petition, it seems like there's enough out there in the public that with that added disclaimer, they understand exactly what they're signing. Is that?
Everything you say is true in terms of the factual description you gave, Mr. Hoskamp, of the material that's out there. But the law is quite clear that a signer is not required to do what you have done. That within the four corners of the petition must be a description of the content of the law. A signer should not have to and is not required to go to these extraneous sources and do this research in order to determine what the petition's about, whether it's factual and clear. That must be in the petition. That's why the law says there must be a description of the content of the bill in the petition. So again, kudos to you for going out and doing all that research, but that is not what's required of a signer. The signer has the right to see a description of the bill, the content of the bill on the petition as it's presented to them.
Isn't this signer beware? Like, if you're uncomfortable with how it's laid out and you can't get you can decline to sign it, right?
Certainly that's one option, Mr. Daunt, but again, apart from that, the law requires that there be a description of the content. So what the law has done here is go beyond signer beware and has actually required that petitioners provide some information. It's kind of like consumer protection law, Mr. Daunt. We have buyer beware, except we have consumer protection laws that require producers of products to affirmatively do certain things. The law affirmatively requires there be a content description on these petitions.
I know you're doing your job, Mr. Brewer, and I respect that. We have same petitions before us, most of them, and I specifically stated my reason for being okay with just the bill number, because I predicted exactly this. We would get an argument from the opponents that, well, this isn't the actual text of the bill. This is just kind of what people kind of call it. And frankly, they've come back. You've made exactly that argument. Again, you're doing your job. There's nothing personal about that. It's frustrating from the standpoint of they bring it forward one way. Well, that's not enough information. Then they bring it forward with seeking to correct that and provide a little more information. Well, that's not the correct information. That's skirting around the text. I'm comfortable with this. I'm going to vote yes on all of these if there's a motion for them. I think these arguments are silly.
With all due respect, Mr. Daunt, these are not my arguments. This is what the law requires. The law says describe the content. These are not adequate descriptions of the content, as Mr. Housecamp's research indicated. You have to go out and find out what red flag law means. You have to go out and find out what the content of this bill of this petition is. Signers are entitled to more than that. It's not me making up an argument. It's there in the statute, it's there in the case law, and it's there in the guidance of this board that you have put out to people. All these petitioners had to do is read that guidance, and they would know they should have described the content of these bills, not what they brought to you this morning.
Yeah. I don't have a problem at all with a recall officer coming back 1, 2, or even 3 times. And I see in the guidance that the Bureau has provided to us that is frequently the case, that a petition is rejected, and there are reasons for it, and the petitioner attempts to create a clearer statement of the reason for recall, and it may be that on the 2nd or 3rd time that the petitioner is successful. So what and I said last time, and the board, I think, rejected the petitions on the basis that simply the number of the act was insufficient. So what we have to decide now is whether adding some title, essentially a title of the bill, whether that makes it sufficient or whether there has to be a more extensive description of the content. And one provision from the statute that I think is important that we discussed briefly last time was that the statute says that if the recall, if the reason for recall relates to legislation, that the petition should not misrepresent the content of the legislation. So I do agree with Mr. Brewer that there has to be some description of the content, and the question that I have is whether what we have is sufficient.
There's the example.
Right. It is, right, 951A C, 1A1C.
It doesn't say it has to be the exact content. It says it must not misrepresent the
Right,
content.
must not misrepresent the content of the specific legislation, which suggests to me that there has to be some representation of the content. That's the negative implication of that, from the way I read it.
Okay.
Yeah. Do we have other questions? I think we should address the issue that Mr. Brewer raised, two issues that he raised. And one was the disclaimer. We talked about that extensively last time. I think there was concern about whether or not there should be a disclaimer on the petition, or whether we should be able to find out who's sponsoring the petitions. But we were advised by the Attorney General that it is not our job to determine whether the form of the petition is sufficient, that we're not here approving as to form. And it appears to me certainly that our job is to determine whether the petition is factual and of sufficient clarity, not to determine whether there ought to be a disclaimer, even if we think there should be. It's not our job to pass on that. So I don't know if we have any other positions on that issue.
No, I mean, that was actually a reason I was considering voting against things the last time around, and we were instructed that it is not within our purview, it's not what we're here for, and therefore any argument related to that is irrelevant to what we're doing here as a board.
Mr. Brewer also raised made an argument that the petition, that the recall language should be typewritten, which I disagree with that as well, because the petitioner is required to use a form provided by the Bureau or created by the Secretary of State or the Bureau, I don't remember exactly which, and the petitioner secures those forms from the clerk. And very few people have a typewriter anymore or access to one. I think trying to find a typewriter to type the reason for recall as opposed to handwriting it, whether printing or cursive, I think would be an unreasonable reading.
An add-on to that is I checked on the election site. In a lot of our business universe, we can find PDF forms that let you fill in the blanks, and it formats and it puts all that in there. In the case of recall petitions, or in the case of any petition for the state, those simply don't exist. So you either have to pay a professional to do it or buy a typewriter. I have a typewriter.
You have a typewriter?
I do.
And the reason we don't do that is because what we've had happen in the past is if we have sent something electronically or anything like that, even if we email a copy of the petition, when it's printed out, it sometimes will shrink it down, or it'll mess up a font size or something like that. And because, as you're all aware, the font sizes and the paper sizes are so strict under election law, that's why we don't do a fillable PDF or even, quite frankly, email a copy. We will mail copies or we will hand them over the counter.
We have, Ann Howard has also asked to speak to item 3 and item 7.
Mr. Brewer, thank you.
Thank you. I'd be glad to come back to address the other petitions.
Of course. Good morning. Have you got?
Thank you.
Would you state your name?
Yes, my
For the
name is
record,
Ann
please.
Howard.
Spell it for the reporter.
ANNHOWARD. I am an attorney licensed in the state of Michigan. My P number is 49379. I'm speaking as a private citizen. I don't have a client. I don't represent anyone. I just have an opinion on Mr. Brewer's brief. I've had the opportunity to read and review Attorney Mark Brewer's brief on this matter. I want to make the following 4 points. First, the brief argued that the recall petition form is defective. To the best of my knowledge, they used the printed form approved by the Department of Elections, form number 2011-2015 revision. I have not actually read the petitions filed in this matter. I've only read Mark Brewer's brief. Counsel has argued that a disclaimer is required on the form. A disclaimer claiming who paid for the document is not necessary here because the document was obtained free of charge from the Department of Elections. Nothing on the form states there must be a disclaimer. The brief took issue with the petitions being handwritten, and he states that they should therefore be disqualified for that reason. The petitions were filled out at a counter, which means they are typically handwritten, and they can't put the entire bill on the petition at the counter. The brief took issue with the description of the bill. The description of the bill in the petition matches word for word the description of the bill on the Michigan Legislature's website. You simply can't write the whole bill on these petitions. In closing, I ask the board to allow the citizens' initiative to move forward, the citizens' initiatives to move forward without any further delay. Thank you.
Do we have other comments from the board members?
Do we have anybody here representing the petitioners? Is there anybody?
We have only Mr. Brewer and Ms. Howard having asked to speak, and I don't see anybody else here. So I do note that there is, and as Mr. Brewer pointed out, there is a difference between the Kofia petition and the McDonald petition. The Kofia petition does not accurately state the title of the act. Rather, it says that Bill 4145 creates an extreme risk protection order. So I just note that difference. I don't know if anyone has a question about that.
And we're taking these individually, is that correct?
Right. So I would suggest that we vote first on item number 3, that is the Kofia order. Do we have a motion? Do we have any other questions?
Just a really quick recap from Heather. Heather, you mentioned our responsibility. The one thing that still sticks with me, okay, I just have to say that, is the fact that we have individuals who are approaching this board filing these petitions. But the reality is, and we knew this last week, the reality is that there's some organization or multiple organizations who remain anonymous who are behind the scenes. And that just, it just seems like that's so against anything, anything ethical. But my question to you is we are not responsible for dealing with that. Is that correct?
That's correct.
The Secretary of State has a way to deal with that once the petitions are submitted?
Well, under the statute, it's the filing official, which for these petitions would be the Secretary of State, has the obligation once they're filed with her with sufficient signatures to determine whether the petition is in the proper form. So at that point, that's when the question would be addressed, whether the disclaimer, now the disclaimer, remember, is imposed by the Campaign Finance Act. So it's not anything really in the election law. And so whatever penalties befall people for not complying with the disclaimer, for not organizing committees, for not filing and creating themselves, those are all penalties that would be addressed, under the Campaign Finance Act and not really in the election laws.
At least it will be reviewed again before It's all
It would be
finished.
reviewed again, and certainly there would be questions. It would behoove people to resolve this issue before filing the petition, right? To determine whether they need to have a disclaimer on it and to have it appropriately titled if necessary before it gets turned into the secretary. But again, that's for the secretary to resolve and not for this board. So they may be in trouble at the end, at the end side of this. But it's still a question, we still would have to decide whether they actually have to have the disclaimer on it, and then what the punishment or the penalty would be for failing to have it at the time that they turn it in. And that would really be for the secretary to resolve.
Thank you.
Okay, do we, excuse me, do we have a motion with regard to, no, let me say one other thing. On the COFIA, I guess that is how it's pronounced, I do find some problem in the fact that the statement of the bill, the statement in the recall language says it is creating an extreme risk protection order. I do think red flag law is something that is generally understood, but the bill does not create an extreme risk protection order. It creates a mechanism for getting an extreme risk protection order. So I think the statement on the COFIA petition is unclear, is both inaccurate and therefore unclear. And not factual. So we're determining both factuality and sufficient clarity. For that reason, I think the COFIA petition is insufficient. I would not be able to approve it.
Madam Chair?
Yes.
So are you essentially saying that on the McDonald petition, that the way they've worded it, that is sufficient
I'm not
in
necessarily saying that. I am saying that I think the COFIA petition is unclear. I think the McDonald petition accurately states what the statute does, that is, creates the Extreme Risk Protection Order Act.
Yeah, but I'm certainly willing to agree with that. I think it's a bit much on the technical side, but if by virtue of saying that the way it's worded on the COFIA is not enough, but it is enough on McDonald, then for the purpose of providing some clarity on these things for people submitting them moving forward, in our ability to move them, through the process without having to come back repeatedly, because I think these people have shown they're going to move forward. They're going to come back as many times as it takes to get this right. My personal opinion is I think these are silly, regardless of which party they're being filed by and which party they're being filed against, but it is something within the law that they have the right to do. And if Extreme Risk Protection Order Act is sufficient where Extreme Risk Protection Order is not, then I'm certainly, for purposes of comity and moving things forward as a board, I can agree with that.
No, I think there's a big difference too. The way that the COFIA is worded is significantly different than McDonald, simply by adding the act and the formatting of it before that too. They don't say the same things.
I'll make a motion then. I move that the Board of State Canvassers determine that the reason for recall printed on the petition submitted by Barbara Willing against Betsy COFIA is not sufficiently clear because it does not accurately or clearly state what the bill has created.
I'll second.
All in favor?
Aye.
The next agenda item, we'll deal with 7 when we get there, but the next item is 4, the recall of State Representative Jennifer Conlon. Mr. Brewer, you wanted to address item number 4?
Yes, thank you, Madam Chair. These 4 petitions had the identical language in terms of the reason state of a recall, that it would, quote, amend the provisions of the Michigan Penal Code that now define and prohibit the crime of ethnic intimidation. I'm not going to recite the legal standards, but there are several reasons why these petitions and these reasons are insufficient. All that this reason states is vaguely the title of the current law. That's the title of the current law. That's what the petition states. It doesn't give a signer any idea about what the content of the bill and what it would become. Matter of fact, the words ethnic intimidation completely disappear from this law under the bill. So it's not only factually inaccurate, it's misleading to use that title, the former title of the law, to describe what this law would do. And again, your guidance, the case law, and the statute itself talk about accurate description of the content. This is an inaccurate title of the bill and has nothing to do with an accurate description of the content. So we would urge you to reject all 4 of these petitions. These are not remotely factual or clear.
Questions for Mr. Brewer? Ms. Howard?
My comments are the same.
So I recall that when we were last here, Member Daunt said that when asked that if he were presented with a petition with the number, that he would pull up on his phone the Michigan Legislature website to determine what that bill number said. And I think that would be asking a great deal of the public. But when I looked at this petition language, I went to the Michigan Legislature website to see what 4474 did, because what this says is that it would amend provisions of the code that now define what it is, but it doesn't say in any way what the amendment is. And so I cannot tell from this recall language what it is that the statute does. And I think it is important, from my perspective, I think it is important for somebody who is being asked to sign a petition that person being asked understand what it is that the representative did, so they can decide whether they agree or disagree with the conduct taken by that or engaged in by that representative. And I simply can't tell from the language on these 4 petitions what the conduct is that the representative engaged in. What what the bill does is amend, but just saying that it doesn't say anything about what the amendment is. So I think that this is not of sufficient clarity to advise the electors of the course of conduct that is the basis for the recall.
I tend to agree with you that someone presented with this particular petition, whether they were for tougher ethnic immigration laws or whether they were opposed to it, would have no way of knowing what side of the line. This is kind of a generic petition that anyone could sign. How many are worded exactly the same way? 6 is worded that way. And
6,
I'm sorry.
where's my,
4 is worded that way and 6 is worded that way as well.
4, 6, 8, and 9.
They have the exact same wording.
Yes.
8 is actually different.
Is it? I'm sorry. Let's see.
No. No, it's not. Okay.
I thought it was the same.
It's not different.
No,
Yeah, that's all. Yeah. Yeah, otherwise they're identical. You don't have an issue with that?
I do not, no. But I'm only one vote.
So on agenda item number 4, petition seeking the recall of Representative Jennifer Conlon, I move that the Board of State Canvassers determine that the reason for recall printed on the petition submitted by Linda Easley against Jennifer Conlon on August 1st, 2023 is not sufficiently clear for the reason I just stated on the record, that it does not indicate it does not indicate with sufficient clarity what the bill does.
I'll second.
All in favor? Aye. Opposed?
No.
Okay. That is number 4. Number 5 is withdrawn. Number 6 is a petition seeking the recall of State Representative Noah Arbit, House District number 20. The language is exactly the same as the language in number 4. I would therefore make the same motion. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Gerald Clixby against Noah Arbit on August 4th, 2023 are not sufficiently clear because they do not indicate to the voter what the bill does, what the bill in question does.
I'll second.
All in favor?
Aye.
Aye. Opposed?
No.
Okay, we will move on. Let me do 8, let's vote on 8 and 9, and then go back to number 7, the Sharon McDonald. Number 8 is the petition seeking the recall of State Representative Kelly Breen, House District Number 21. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Kayla Toma against Kelly Breen on August 7, 2023 is not sufficiently clear for the reasons stated with regard to the recall petitions against Noah Arbit and Jennifer Conlon.
Madam
Is not-
Chair.
Okay. Is not sufficiently clear because the language, which is identical to the language against Jennifer Conlon and Noah Arbit, does not indicate the conduct, is not sufficiently describing the conduct of the representative for which recall is sought. I'm muddling that one.
Yeah, it doesn't, yeah. Can you read that back to me?
Would it be helpful if I read the last
Could you?
two motions?
Let me just say it again. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Kayla Toma against Kelly Breen on August 7, 2023 are not sufficiently clear because the recall language on the petition does not sufficiently describe the conduct of the representative and does not describe the content of the bill, number 4474.
It does describe the conduct of the representative. They
Right.
voted yes.
You're right. It does not describe the content of the bill,
Context or the content.
content.
Are you,
It does not describe how the bill amends the provisions of the Michigan Penal Code.
just for fun, Adam is typing, just for fun. Do you have a different wording?
So I can read the last two motions if that would be helpful.
I was trying to essentially
wasn't
incorporate
sure.
the language that I had previously articulated, but I kind of messed it up and confused us instead.
So the motions for agenda item number 4 and number 6 were that the reasons for recall were not sufficiently clear because they do not indicate to the voter what the bill in question does.
Can we use that same wording?
It's completely up to you.
Yes, I would suggest that we use the same wording with regard to agenda item number 8, the recall of Representative Kelly Breen.
If we're using that same wording, I would second it.
All in favor?
Aye.
Opposed?
No. Excuse me, no.
I just want to state for the, just to make sure I was clear for the record. So the motion that was that was just entered was that the reasons for recall submitted against Representative Breen are not sufficiently clear because they do not indicate to the voter what the bill in question does.
Yep, the
correct?
focal point of why we're disagreeing, if the focal point of what we're trying to get across is that the clarity is not there for someone to make an intelligent decision about whether they support or whether they reject Kelly Breen's vote of yes.
That's correct.
Yeah.
Thank you. I just wanted to clarify.
Okay. Agenda item number 9, the petition seeking the recall of State Representative Denise Menser. Want to make a motion?
Sure. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by John Zupak against Denise Mensker on August 7th of 2023 are not sufficiently clear. And Adam, I would add to that the description that you have put into the previous 3.
So just to be clear, so it's not sufficiently clear because it does not indicate with sufficient clarity what the bill does, is that?
Correct.
what your motion is. Okay.
what they're even objecting to, yes. Doesn't make it sufficiently clear as to what the basis for that recall is.
Second? All in favor?
Aye.
Aye. Opposed?
No.
Okay, and we have one more agenda item, and that is number 7, the petition seeking the recall of Sharon McDonald, which, as we've noted, differs from the recall petition language with regard to Betsy Kafia. I would add that I did the same thing that you did. I went online and I looked for red flags.
Site must have been very busy last night.
And I do think that the language, red flag law, is something that is widely used, both in the legislature and in the comments and media reports about what the legislature has done. So in that regard, I would disagree with Mr. Brewer about whether the word red flag law is unclear. I think that it is clear not just in Michigan, but sort of around the country. Extreme risk protection orders are almost where there may be different language with regard to how legislatures characterize the action that they're taking. I think red flag law is something that is generally understood. So the other question that I have is whether voting yes on Michigan House Bill creating the Extreme Risk Protection Order Act is sufficiently clear. Does that let the voter know, the voter whose signature is sought, does that sufficiently inform the voter so that they can make an intelligent decision? That is the question that you just asked, Member Hauskamp, and I think that is the question. Does it allow the person whose signature is sought to make an informed decision?
You know, in this particular case, it just strikes me, it's pretty clear that there's one activity here that's being reviewed, right? The creation of the Extreme Risk Protection Order Act, which Sharon McDonald voted yes to accomplish.
Right.
That has a lot of clarity. The one we voted down a few minutes ago had no clarity to it. The yes vote could have indicated you were either for or against ethnic intimidation. This petition, I think, is succinct, and I think it's clear. And I also think it's factual. The Extreme Risk Protection Order, creating it, is exactly what is in the Michigan House documentation.
Right. Which is appended.
Right. I did cut off section 7, by the way.
I'm sorry.
Section 7 is at home in the printer waiting for more paper.
And the summary attached to the recall petition states
Yeah.
the same thing. Any further discussion? Do we have a motion?
Yeah, I'll make a motion. I move that the Board of State Canvassers determine that the reasons for recall printed on the petition submitted by Michael T. Ross against Sharon McDonald on August 7, 2023 are factual and sufficiently clear because it provides an accurate description of the legislation's intent.
I'll second.
All in favor?
Aye.
Aye. I believe that we have addressed all of the items on our agenda except for item 10, Do we have any other business before the board?
If I may, before we move on to other business, I just want to clarify. Recalls are a little bit unique in the sense that where normally in this context, where a 2-to-1 vote would mean the motion would be adopted or approved or whatever the motion was, in order for the recall petition to go forward, it has to be an affirmative vote of 3 or more. So out of all of these ones, the only one that goes forward is the recall petition submitted by Michael Ross against Sharon McDonnell, agenda item number 7. So I just wanted to make that clear for the record.
Right. Do we have any other business?
I do not have anything unless the board has any questions.
Nothing for me.
It's 11 o'clock.
If I might, sorry to interject. Can you all hear me? I apologize to interrupt.
We can hear you, yes.
Just a clarification to what Adam said, the 2-to-1 would be sufficient as long as it included one vote from a member appointed by each party, which was not relevant here, but just to clarify for the record, 2-to-1 would have been sufficient. In other contexts, not with recalls, but in other contexts, there are times when a 2-to-1 vote with 3 members present is sufficient if they are of different parties, the 2 yes votes.
Good. All right, so it is 11 o'clock, and I call the meeting closed. We may be back, but